Water etiquette on the western slope is our presentation today. My name is John Rizza. I'm the small acreage management specialist on the west slope. And we're here with Aaron Clay today, who's an attorney and former water referee for Colorado Water Court. Today we're going to talk a little bit about, as I mentioned, the water etiquette in Colorado during a drought year. We're coming to you from Grand Junction today. We want to understand your knowledge about water law in Colorado, and if you'll take part in our poll here real quick, we'll pull that up. You go ahead and fill out this poll for us. We'll talk for just a minute here and see if we can understand your understanding of prior appropriation and water rights here in Colorado. All right, looks like we're getting some good votes in there. If you wouldn't mind continuing to fill that out, we'll take another second here to fill that out. In the meantime, we just want to emphasize that this webinar is going to be recorded and posted to our website for future reference, and that we're also having another webinar here next week on the drought situation in Colorado from the state climatologist. So stay tuned for some more of those, and you can register for any of these on our website. And go ahead and log in and get registered just like you did for today. So it looks like we got a pretty decent amount of people who put in their vote. So I'm going to go ahead and turn it over to Aaron for his presentation today.
Thank you. I'm Aaron Clay. I'm a water lawyer and a general lawyer in Delta. I've lived in Western Slope all my life, and I teach a class from time to time every March at the Technical College in Delta, and from time to time around the state. It's called Water Law in a Nutshell. And I'm going to give you about 10 or 15 minutes of that just to give you some background in the prior appropriation doctrine before we begin actually talking about water etiquette and how to share water, I guess, in a drought situation. The Colorado doctrine is called, also known as the doctrine of prior appropriation, is what we use in Colorado to establish water rights, to be able to use water in Colorado. The water belongs to the public by our Constitution, and so a water right is a usufructuary property right, meaning that you have the right to use it, but you don't ever get to own the water. The water is always owned by the public, subject to your right to use it in accordance with the rules. In the Colorado doctrine, also known as the prior appropriation doctrine, and here on the screen are four of the principles of that, basically. The primary one that we're going to talk about today is water rights owners may build facilities on the lands of others, and so we have ditches that run across other people's properties. That's an important part. The phrase prior and prior appropriation is important. What it means that the senior water rights holders have better rights in time of short supply. And your water right is based on first in time, first in right, meaning that whoever went to the stream first, or whoever drilled their well first, or built a reservoir first, gets the first right of use before anybody else gets to take their water right. And they can use it to the extent that they have a beneficial use for it. Typically today we'd be talking about irrigation as a beneficial use. They can use it only to the extent that they have a need for the water and can use it without waste. That's one of the doctrines. And so, for example, in the Western Slope, one of the duties of water for irrigation is typically 1 CFS to irrigate 40 acres. That means that if you had a 40-acre parcel of land you were irrigating, when you went to court to get your decree would be entered as a 1 CFS decree to irrigate that 40 acres. Appropriation means that you actually take water from the stream, with one exception. The Water Conservation Board can hold in-stream flow rights for environmental purposes, but private parties have to appropriate the water by taking it from the stream and put it to a beneficial use. You have to have a plan to divert, capture, possess, and control the water, and once you do that and apply it to a beneficial use, then you can decree the water. And that decree is done by an adjudication process. In some states, they use a permit process where the division engineer just enters a permit for the amount of a certain use of water. That's how they do it in Utah, for example. But in Colorado, many years ago, we came up with a process which is a judicial process, and that's why we call it an adjudication. The word judge is in the middle of that word. An adjudication is a court process where the judge listens to testimony, looks at exhibits, maybe even visits the site, and then decides whether or not the water right is appropriate to be decreed. The judge then confirms that the water right will not cause injury to any other holders and enters a decree. And the decree is given the date. The date is based on the year in which it was filed. So a 2012 filing will get a 2012 priority. And the key there is that the more senior your filing, the more senior your water right. So a water right that was filed in 1912 is more senior to a water right that was adjudicated in 2012. That's really important. Water courts, there are 7 water courts strung around the state of Colorado, 1 in each division. Water courts set the priority date. They establish the amount that is available to that water right and the year when the appropriation was initiated. And again, the key is the year in which it was adjudicated. In Colorado, we do not use the public trust doctrine. The water rights are adjudicated based solely on the amount appropriated and the use to which they were put and when they were put to use. We do not check into the public interest doctrine in Colorado under the Colorado doctrine. Once you get your decree, then you have a property right. A water right is a special kind of property right known as a usufructuary right. Ownership of the water remains in the public, but you have the right to use it under the rules of the Colorado doctrine. You've heard the saying, probably, use it or lose it, and that's one facet of a usufructuary right. That means that the value of your water right is its historic use. What have you put the water right to use for? Irrigation or domestic or stock water or whatever, and that is what establishes what you can continue to use the water right for, is its historic use. You're also required to take only the amount of water you need and to leave the rest in the stream and to return whatever wastewater or return flow you have directly to the stream, because we want it to be used and reused as many times as possible to maximize the beneficial use of water in Colorado. The prior appropriation system also lays out a system of enforcement, and that means that we have people who are paid by the state to enforce the decrees that the judge lays out. So anytime a judge issues a decree, it is sent to the division engineer. There's a division engineer in each of the 7 water divisions, and they all answer to the state engineer, who's appointed by the governor. The division engineer gets a copy of that decree, and then his or her job is to enforce that decree in accordance with the order of priority. The division engineer has usually 1 or more persons that work for them who are called water commissioners, and we're going to see what the water commissioner's job is in just a second. But basically, the water commissioner's job is they're the cop on the beat. They're the policeman who decides who gets water and who doesn't get water. Because it's first in time, first in right, and the senior water rights get taken care of before any of the junior water rights, we have some ways to allow junior water rights to take water that otherwise would be shut off. And some of those ways are augmentation plans, exchanges, and substitute supply plans. Exempt wells are also another example, and a feudal call is another example. A call is a term of art when the senior water right holder who's downstream is not getting their entire share of water. They do something called calling the stream, which means that they call their water commissioner. Nowadays, you usually text them or they leave a voicemail message, and they say, I'm calling the stream, meaning I'm only getting part of my decreed amount of water. Then the water commissioner goes out and sets the call. He takes his priority list, and he first of all cuts everybody back to only their decreed amount. So that's called the free water stage, when there's water for everybody. and then he cuts them back to their decreed amount. Once if there's still not enough water available for the senior water rights holder, then he starts shutting people's head gates, and the most junior water right gets shut off first until there's enough water to satisfy that senior calling water right. That's basically what a water commissioner does. He also does maintenance of diversion records and some accounting and those kinds of things. And I've got a picture here of Ralph Parshall, interesting guy. For water commissioners to be able to do their job, they have to be able to measure the water. And the primary tool that we use in Colorado for measurement of the water is called a Parshall flume. And it was invented by a CSU professor about 100 years ago, Ralph Parshall. And what he did was he ran tests and measurements over a course of time to come up with a specific design for a mechanical device. And all this device does is it squeezes the water into a narrow channel. And the squeezing of the water causes the water to rise on a ruler that's on the side of this flume. And that ruler is marked off in tenths of an inch. And depending on how high the water is running through the flume, the water commissioner can use a table or a graph to determine how much water is running through that particular flume. So this flume probably is a 9-inch weir, and all the water is going through that's in this ditch. And so using the mathematical formulas, Ralph Parshall developed a method for determining exactly how much water goes through that. It's called a Parshall flume. You'll see them all over Colorado. To help folks who came to the stream late and weren't able to get their water right, we have some process called a plan for augmentation. And a plan for augmentation goes through a court process and is decreed, and then is administered by the water commissioner like any other decree. It is a plan to bring replacement water to the stream so that a junior water right user can take their water and not get called out. Under the statute for a plan for augmentation, you have to provide replacement water to the senior water right, and you have to provide it in the time, location, quantity, and quality of the water right that you're taking out of the stream. But if you can do that, then you're allowed to keep your junior water right and use it even though it's out of priority because you're providing replacement water. This is very typically done when you have a well and their well is a junior water right to senior irrigation water rights, and the well owner then goes to a reservoir, typically buys some water or leases some water out of the reservoir to provide it to the senior water right holder. When you have a water right, it is a property right. And as all property rights in Colorado or anywhere, there are certain rights that you can use, certain things you can do with a property right. You can buy it, you can sell it, you can transfer it, you can mortgage it. You can sell it with or without the land. That's unique to water. In Colorado, you can take the water away from the land and sell it. And you can change it. And the key to a change of water right is if you want to change a water right, suppose you have an irrigation water right and some city wants to buy it and put it into their municipal treatment plant. They're going to have to go through a water court process to change the type of use from irrigation to municipal. They can do that. They might want to change the place of use, the time of use. For example, an irrigation water right is not in priority in the non-irrigation season, so you might want to change the time of use to a year-round use. A change in point of diversion or a change from direct application to storage. Those are all various kinds of changes. The key to doing a change of water right is that it keeps its original priority. And that's key because, as we know, first in time, first in right. And the value of a water right is its priority and its historic use. And so you would want to keep your original priority and your place in the priority list even though you make a change. The court, when it looks at a change of water right application, is required to grant the change if there is no injury to other users on the stream. So the court will look and see what other water rights are there on the stream. How could they be injured by the change that's requested? And if there's no injury, then the change is granted. More typically, there are terms and conditions put into the new decree for the change that says you can only change it if you do this and this and that to make sure there are no injuries to the other stream. I have a question from from a listener out there who asks, when you buy property and it includes water rights, does the seniority of the water rights stay the same? And the answer is yes. And just like a change case, when you transfer water rights, you're transferring a bundle of property rights, one of the important attributes of which is its priority. I'm going to skip this ditch owner's responsibilities and maybe come back to it. Let's talk a little more about what it means to have a property right and what the priorities are. One of the advantages to the prior appropriation system is it is a very certain system, meaning that once you're on the priority list, you know where your water right lays, you know when you can get called out depending on the stream conditions, and everybody knows it's a very certain system. But sometimes a system's greatest strength is also its greatest weakness, and that's probably true with the prior appropriation doctrine, because it's not a very flexible system. If a senior water rights owner calls for their water, the water commissioner is required to shut off a junior, even if that doesn't seem to make sense, or even if it seems harsh. That's just the way it is. The senior water rights holder is entitled to their water, and they're entitled to it regardless of whatever else is going on in the stream. That has a disadvantage of not allowing much flexibility up and down the stream. So people have, from the very beginning of Colorado water law, have bent the prior appropriation system by doing voluntary exchanges. Farmers get together and the junior water right holder asks for a little water, and the senior water right holder would say, you know, I'm going to quit haying, I'm going to be haying in a week, I'll release my call in 3 days, so be ready, you can take some water for a week while I'm haying. That happens all the time. People on ditches a lot of times will do what we call rotation system, where the several people on a ditch will get together and they will say, okay, you take the water for 3 days and I'll take it for 3 days, and then you get it for 4 days, and then they rotate around and they get a 3-day on and 4-day off, or whatever kind of rotation. That's not strictly within the prior appropriation system. That is an accommodation that those water users have made among themselves just to make it work. That sort of rotation system works very well in lots of small ditch situations, because the amount of water that's available to the entire ditch may be enough to irrigate a field, for example, but if you cut that in thirds, if there's 3 users on the ditch with equal shares, you cut that in thirds, they may not even, none of them may be able to water. But if they share and they take all of the water for a third of the time, that's better than a third of the water for all the time. The Colorado Supreme Court recently had issued a decision that says those kinds of rotation agreements are not enforceable, even though they've been in place for 50 years, unless there is something recorded in the real estate records that makes them binding. So if you and your neighbors have gotten together over the course of years, and you know it's just been the way that you've always done things, and then someone moves in and buys a property and they own a third of those water rights, they do not have to honor that historic rotation system unless there's something recorded. So what I do for my clients typically, if they're doing a rotation system like that, is we will create a covenant similar to a covenant that you would have in a subdivision. The covenants in a subdivision talk about, trash hauling and that kind of stuff. For these kinds of covenants, we talk about who owns the water and what they're going to use it for and how they get it done. And then once we record that covenant, it becomes binding upon the users of all those water rights and on down the road. We usually are pretty careful not to say that they can't sell their water rights, because we wouldn't want to take away their economic value by creating something in a rotation system. But I do a lot of those water use agreements or water use covenants. In fact, a lot of times in a subdivision situation, the county requires that kind of a water use agreement to be recorded, because counties have seen over and over the fights that come down the road when you take a parcel of agricultural land and split it into subdivision lots, and then the fight is on who gets to take the water rights. Let's go back to the ditch owner's responsibilities. If you have a ditch in Colorado, you have certain responsibility, and those responsibilities are basically to keep the water in your ditch. If you have a ditch and you don't take care of it, and that means keeping the banks clean and keeping the rodents out and cleaning it out of moss and weeds and other things, and it overtops the ditch and floods someone, then you're pretty much strictly liable for that. It's not quite strict liability, but your obligation is to keep it in the ditch. And if you can't keep it in the ditch, then you're pretty much going to be responsible for that. That's true whether it's a ditch company owned by the Grand Valley water users or whether it's a little tiny ditch owned by 1 or 2 people. Here I'm putting on the screen a couple of statutes that talk about what the responsibilities are for maintenance and repair of your ditch. I get calls every spring from people who say, my neighbor's out here in the backyard and he's got his backhoe and he's digging something up, and I didn't even know there was a ditch back there. Well, under Colorado law, every ditch has an easement that goes with it, and the reason is, a couple of reasons. One is that there's a constitutional provision that allows you to do a private condemnation of your neighbor's property if you need to do that, and the Supreme Court says that that creates an implied easement for every ditch. And secondly, these statutes that I just put up on the screen show that the ditch owner has an obligation to keep their ditch clean. That means they have also the right to go across your property if they need to clean that ditch. We don't have a lot of problem with people cleaning their head ditches, because if they don't keep them clean, they don't get their water. The problems that I see are typically on tail ditches, because once somebody's irrigated with it and it's gone off their property, they forget about it. But in real terms and under the law, they have an obligation to maintain that tail ditch all the way back to the nearest natural stream system. Oh, we're not going to go to the Colorado River Compact. The property right can be transferred, mortgaged, and changed subject to the non-injury rule. And when you do that, there is a market for water rights. Somebody has asked me if there was a market for competing uses. There's a market for water rights, but that market is in some places very limited. The value of a water right is based on its location, priority, and historic use. So depending on location, it may or may not have any value. For example, a 1 CFS water right with a senior decree on the Slate River near Crested Butte has tremendous value, because there is a lot of development up near Crested Butte. There is not a good source of water above that. There's no storage particularly. And so to develop up there, you need to bring some water to the stream. And that creates a good market up there. That same seniority priority water right down near Delta probably has very little value, because there's not very much development pressure near Delta that doesn't have water available for it. There's no downstream call other than the Redlands Power Canal. And so there's not a lot of value for a water right in that situation. So location is critical. The priority is also critical, because the more senior the water right, the more value it has, because then that avoids the call by other water users on the stream. And the use is also critical, because water is measured by its historic use. If you can't show any historic use of your water right, it has no value. Very important for people to keep records about when they used water, how much they used, and what they used it for in a log or a journal or something, because someday they may want to convey that water right or sell it, and if they have no proof of historic use, they'll have no value there. I'm going to put up a list of websites that you can copy down. This are places that you can go to learn more about water rights, and I'll just leave that up for a second so you can all copy those down. The third one from the bottom I'm going to plug a little bit. That's the Colorado Foundation for Water Education. It's a nonprofit statewide organization that's mission is to educate people about Colorado water law. They put out several guides every year. They put out a quarterly magazine. They have the Citizen's Guide to Colorado Water Law. Citizen's Guide to Water Quality, Citizen's Guide to Plans for Augmentation, lots of those kinds of things that are very useful. So if you're not a member of that organization, you might want to become one just to get those kinds of things. I've been talking for about 25 minutes, I guess. Is there anybody out there that has a question for me? Dave asks, give me an example of where a change of water right must not injuriously affect another water right. The typical change that we see is a change from irrigation to domestic or municipal, because a municipal provider like the city of Thornton may be short on water, and the most available source of water is some farmer who's ready to retire and is ready to sell his farm, or will respond to a large offer of large dollars to give their water right up. For the municipality to be able to use that water right, they have to change the use from irrigation to municipal. In doing that, they have to go through a water court process, change application, and the water court looks at that water right and says, is this going to injure anybody? And so the injuries that we look for are who is the senior water right on the stream? Actually, the non-injury rule applies to both seniors and juniors. Who else is on the stream? And if we allow this municipality to take this water off of this field and transfer it to their treatment plant, for example, and then who could that injure? What other water rights are there? For example, there might be junior water rights downstream who have historically relied upon the return flow that came off of that field and went back to the creek. If we take that return flow away by allowing them to take that into a treatment plant, that could injure that downstream junior because you won't have the availability of that water. One of the terms and conditions that might be placed into that conditional decree or that change decree would be the term and condition that a certain amount of water has to be left in the stream to be available for those downstream water users like they historically have made. The next question I have is, can you explain the expansion of use and why it only pertains to eastern slope? I can explain expansion of use, and it does not pertain only to eastern slope. On the western slope, we have heard about that because it's been a challenge that the west slope water users have made to the east slope. Expansion of use is a doctrine that comes from the fact that a water right is a usufructuary right. And when you get a decree for the water, it's decreed for a certain amount of water for a certain use, typically 1 CFS to 40 acres, let's say. Expansion of use is the idea that you're using water outside of your decreed amount. So if you had a decree that allowed you to irrigate 40 acres, and then you began irrigating 60 acres, you've expanded the use of that water. The rule is that every water user is entitled to the stream as they found it when they made their appropriation. So if I'm a junior water user and you had a 40-acre field when I came to the stream and made my appropriation, and then you expanded your use to 60 acres, you have now taken more water out of the stream than you were taking when I made my appropriation, and that's to my injury. And so I have a right to complain about that and limit you to your historic decreed uses, 40 acres in this example. And the reason that we're talking about that now is because there is some concern that the water rights, the water users on the eastern slope that take water out of the upper Colorado River Basin and take it over to the eastern slope, they have begun expanding their use. That's the claim anyway, meaning that they're using it for water it was never decreed for. They don't have a judicial decree that covers that. And to the extent that they're taking water and using it outside of their decreed amount, that's to the detriment of other junior water rights holders on the western slope. But the expansion of use doctrine means that you cannot expand your water right beyond what your historic decreed use was. The next question I have is, what additional challenges would a change toward in-stream flow have? In-stream flow is a in-stream flow water rights are water rights that were created in 1972. They allow the Water Conservation Board, which is a statewide agency, to make filings in water court for water to be left in the stream for environmental purposes, to preserve the environment to a reasonable degree. And the problem with in-stream flow is that under the priority doctrine, the first in time, first in right, they're very junior water rights because the first ones only came to water court in 1973. And so they're very junior to other water rights on the stream. The legislature a couple of years ago passed some statutes that allows people now to take their senior water rights and change them to in-stream flow. That wasn't allowed until about 2 or 3 years ago. There are challenges with that because anytime you change a water right, you have to make sure that there's no injury to anyone else. So in the court process, you have to show that changing this, which was historically a consumptive water right at a certain location, to a non-consumptive water right at maybe a completely different location has no negative impact on the stream. The other ramification is that the changed water right pretty much has to go out of business. If I take an irrigation water right and change it to an in-stream flow, I have to dry up all that land that I was irrigating with that, or otherwise I've expanded my use by continuing to irrigate. Next question I have is, what is the process for a senior water right holder to place a call on the river? Basically, the senior water right holder notifies the division engineer or the water commissioner for that area that they are water short, meaning that they have a decree for, let's say, 2 CFS for 80 acres, and there's only 1.5 CFS in the river at that time. That means that the water commissioner then has to go out to the other users on the stream and shut off their head gates. And under the theme of our topic today, which is etiquette, many times senior water rights holders choose not to place a call just to keep their neighbors in water, because if they place a call, there is no such thing as a selective call. You cannot say, I want to call out Bill or Sally, but not June. If the call comes on, it just is administered in the reverse order of priority, and so the most junior water right gets called out and then on up the list of priorities. So many times a senior water right holder will choose not to call so that their junior upstream neighbors will continue to be able to get some water at least. And many times that's done on a negotiated basis. For example, in 2002, the Redlands, which was the last big year of drought prior to this year, the Redlands Power Canal and the Colorado River Water Conservation District got together and they agreed that the Redlands Power Canal would limit their call to 600 CFS instead of 610 CFS. That 10 CFS difference in their call meant that 20 acre-feet a day was allowed to be kept in storage in Blue Mesa Reservoir for later season release. And the deal was that the River District agreed to pay Redlands Power Canal the dollars that they lost by not having that 10 CFS running through their pinstocks generating electricity. And so at the end of the year, they accounted for how much electricity they could have generated if they'd had that other 10 CFS. And it turned out to be very, very cheap water for the River District. Kept some water in Blue Mesa Reservoir that got released in September and October to keep the stream alive. It was a very good negotiated deal to where a senior water right agreed not to call at least a portion of their water right. Question is, why do I see irrigation in Douglas County but not Elbert County? That may be a function of the wells out there. In Colorado, wells have special priorities or special rules. There are 2 kinds of water right in Colorado, 2 kinds of underground water, groundwater in Colorado. Most groundwater in Colorado is tributary, meaning that at some point it will impact a natural stream, either adding or taking water from a natural stream. There's also non-tributary groundwater, and that non-tributary water is so deep and has been there so long that it does not affect a surface stream in Colorado. We treat those 2 kinds of water rights completely differently. Tributary water is treated as if it were surface water, and so you get a well permit and you have to go through the water court process and get a decree, and then you're treated just like a ditch on a stream as far as being shut off. Because of the fact that you can't shut a well off as efficiently as you can shut off a head gate, To get a well permit, you also probably will have to have a plan for augmentation to produce some other water, but that's a different topic. Non-tributary groundwater is allowed in Colorado to be mined, much as oil and gas is mined. We allow you find out how much water is under your 40-acre parcel in Elbert County, for example. You get a hydrologist to verify how much water is there, and then you're allowed to divert and use up 1/100th of that amount every year, on the theory that there's water there for 100 years, and we'll deal with that when that well runs dry in 100 years. That has been a problem for Douglas County recently, because they've discovered that what they thought was a 100-year supply may turn out to only be a 40 or 50-year supply, and they have lots of subdivisions in Douglas County that were built with the idea of using only non-tributary groundwater, and now they're going to run out of water before they thought. So they've been thinking about that. Next question I have is explain feudal call. When the water commissioner goes to administer a water right because a call has come on, they go to the head gate or the spring or whatever the water source is, and they shut the head gate off. But if the head gate or the spring, more typically a spring, is in a location where shutting off that particular source of water will not provide any water to the calling right downstream, that's called a feudal call, and the water commissioner does not have to honor the call for that particular water right. The idea being that it doesn't make sense to cut somebody's water off if it's not going to really help someone else. That the decision on whether it's a feudal call or not is made by the water commissioner on a case-by-case basis. It's typically done only for remote springs or those kinds of things where if there's a 15-gallon-a-minute spring a mile from the nearest stream, clearly that's not going to help the stream to shut that spring off. Next question I have is explain the adjudication of wells and why it should be done. Well, there are some kinds of wells do not need to be adjudicated. Those are exempt wells. We have a doctrine which says if you have a small capacity well, 15 gallons a minute, you're using it for small uses, typically domestic uses, you can get a well permit because we create a legal fiction that says that that well is not going to injure anybody else on the stream. Not true, but we allow that to happen even though there's a small amount of injury. Those kinds of wells, which are called exempt wells, do not need adjudicated because they're outside the priority system by definition. Wells that are adjudicated are other kinds of wells, which are called fee wells. And then you get a well permit. Most of the time you have an augmentation plan. And that entire package of the groundwater for the well and the augmentation plan that protects that well from the senior call is adjudicated so that the court has the opportunity to look at the augmentation plan. And the criteria for decreeing a plan for augmentation is exactly the same as the criteria for a change application. And that is, we have to verify that the operation of the plan for augmentation will not cause injury to any other water user on the stream. Most augmentation plans are pretty complex. They have bells and whistles and conditions that if this happens, then this water will be provided. If that happens, this water will be provided. And the court decrees those, and then the water commissioner administers them accordingly. I've got some more questions here. Question: can I lock my gates for security and expect the ditch rider to notify me when he needs access? Or must I always keep gates unlocked to provide that access? This is a good question, and it goes to the issue of what's the reasonable uses of the landowner and the ditch owner. This is a situation, typical situation, where you have one party owns a parcel of land that somebody else's ditch crosses, and this creates conflict all the time. And the question is whether or not I can lock out the ditch rider and just make him notify me when he wants access. And I think the answer is no. I think you have the right to put a gate and expect the ditch rider to go through a gate, but I think he has the right also to a key to your lock. Or more typically, what I recommend to people is that you have two locks linked into the gate, because then if the gate's left open, we know who was the one who left the gate open by whose lock is open to go through there. Ditch owners in Colorado have a lot of protection from the Colorado Supreme Court in the use of that ditch. Many cases that talk about their super priority to the use of the ditch, and the owner of the land that the ditch crosses has no right to put something in the ditch, no right to change the ditch, no right to make any use of the ditch without either the permission of the ditch owners or a prior court decree. You can't go make the change and then wait for them to sue you. You have to go to court first and get a court order that says that whatever you want to do to the ditch is not going to negatively impact the ditch owner themselves. Next question is, personal food production for household use should be a legal use of water from a household use well. Would you agree? I think I disagree with that. If I understand the question, I think what they're talking about is they've got a little garden and they want to produce tomatoes and Swiss chard out of the garden for their own household. That is considered, that's a different use. Household use, by definition in the Colorado statute, is use within your house. You're not even supposed to put your water through a garden hose on the outside if you have a household use only well. A household use only well is one of the legal fiction wells, we call them exempt wells, that are outside the priority system. And the reason that we've made them exempt is because we feel like the state of Colorado, at least at one time, felt that these are such small wells with such small impact that we're just going to ignore them. But if you allow someone to have a lawn and garden, now you've expanded that impact. That's an expanded use. Instead of using it just in the house for consumptive uses of cooking and sanitation, now you've got irrigation outside the house. And irrigation is much, much more consumptive of water than household use. Typically, if you have a house with a septic system, only 15% of the water that's taken in that house through the well is actually consumed. The other 85% goes back through a leach field and septic system to the stream eventually. It might be years before it gets back to the stream, but eventually that water is going to get back to the groundwater source and back to the stream. What you irrigate with, only about 50% of that gets returned to the stream, and it gets returned in a different manner. So I think that's an expansion of use, and I wouldn't see that as being covered by household use only. Could I discuss a good approach for landowners trying to agree to share a ditch? 4 landowners want to determine a way to rotate the water on the ditch between them all. Yes, the typical way we do that is by acreage irrigated. Let's say we have 4 landowners on a ditch and they each own shares of the water right. There's 2 ways we do this sort of rotation system. One is that we determine the acreage that each one of the landowners is irrigating, and then we allocate the water based on that acreage. So if someone has half of the acreage, total acreage of all 4 landowners, they get the water half the time, and the other 3 owners would be prorated that way. The other way we do it is by ownership of the water itself. So if the person who has half of the land only owns a quarter of the water, and that could happen, then they might only get it 1/4 of the time, which means they may not be able to irrigate their entire parcel, but that's fair if that's all the water they're producing. Those are 2 of the ways. The other thing you have to be careful of when you do a rotation system is the uses of the water. If you have, and this is more and more common now, we have someone who subdivided, they put a house up, and now they're doing bluegrass and garden irrigation, and they're all in a rotation system with a couple of other people who are doing hay irrigation. You know, a rotation system on a hay field is pretty easy to do because you get over a hay field, you don't have to irrigate it again for 10 or 15 days, and your hay will be fine. In fact, you don't want to irrigate it too soon, or you will yellow it out from too much water. But bluegrass is different. Bluegrass has to be irrigated every 3 to 5 days, about 7 days maximum. And so you got to be careful with that rotation system that whoever's watering their lawn and garden has at least a portion of the rotation for within 5 to 7 days, something like that. Question is there a difference between a household use well and a domestic use well? And are there exempt wells that allow irrigation up to 1 acre? Yes, both. The answer is yes. In Colorado, they're the exempt wells. There are two kinds. There are three kinds actually. There's a exempt household use only well, and you can get that kind of a well permit if you have a parcel of less than 35 acres that was created by some process prior to 1972. Then you can get an exempt household use only well, and that's the one I was talking about earlier that just allows you use in the house. If you have 35 acres or more, then you can get an exempt domestic well. An exempt domestic well allows you to have household use in up to 3 single-family residences, up to 1 acre of lawn and garden, and some what they call domestic stock, which means a few horses, a few cows, but not a feedlot. There's a third kind of exempt well. It's called a commercial well, and that would be if you have a parcel that's less than 35 acres that was created prior to 1972, and you want to put a little fruit stand or a mom and pop store or gas station or something on there, and you can get by on less than 108,000 gallons per year, then you can get an exempt commercial well for the use of that, for that particular use. I'm getting a question, one more. I'm going to put the Colorado River Compact up here. I put this up here just in case we ran out of time. We could talk about it, and we may run out of time. I'll put it up here just so you can have this if you want to read it later. And the question is, if there's a senior water right that is becoming available, i.e. power plant decommission, how does water right allocation get settled? If a senior water right is becoming available, there are two ways that a senior water right might become available that I know about. One is there's a doctrine in the prior appropriation system called abandonment. If you have a water right that has not been used for several years, then the court could abandon that water right. There's a process every 10 years where the division engineer lists all the water rights that they consider to be abandoned, and then the court decrees those. That would then eliminate those water rights from the priority system. The other way that a water right could be eliminated would be by voluntary relinquishment. Sometimes water rights holders just say, I'm going to give up my water right. That's usually a negotiated deal between two water rights users that one of them, for some reason, some political reason, they say, okay, I'll give up my water right. What happens in either of those situations, abandonment or a relinquishment, is that that water right just ceases to exist, as if it never was a water right at all. And the practical effect is that everybody on the priority system moves up one notch. So what if the priority number 3 on the stream gets abandoned or relinquished, then what was priority 4 actually becomes priority 3, and so on. Everybody just moves up one. That water right does not become available to anyone else. It simply goes away as if it never existed. The allocation then is the same, it's just that the list has changed a little bit. The next question I have is, does degradation of water quality count as injury in a change case? And the answer is only if an augmentation plan is being part of the change case. A pure change case where we're only talking about changing an irrigation water right to municipal use, for example, water quality is not part of the decision in a prior appropriation in the Colorado doctrine, only quantity. But if, as part of that change case, they're also proposing a plan for augmentation to protect downstream juniors as part of the change to eliminate that injury, then the court would look at quality, because one of the attributes of a plan for augmentation is you have to replace the water in the time, location, quantity, and quality of the water that you're taking out. Next question is, how do you find out who has the senior water rights? I'll go back to the last page. The very top website is the Division of Water Resources. This is the division engineer's office. This is the office that employs the water division engineers and the water commissioners, and they have a very good database there that has all the water rights. So if you go onto their website, you click on water rights or structures, I think it is, and then you ask for all of the decrees on Razor Creek, for example. They'll pull up all the decrees on Razor Creek. And then you can just print off that list, or you can look at the decrees themselves to see what the decree says. The other way you find out is you call the water commissioner, because they used to be they carry it in their back pocket, now they carry it on a little laptop or a iPad or iPod or something that they carry the seniority list, the priority list for every stream that's under their jurisdiction. Okay, next question is, does a landowner have the right to run a fence over navigable sections of a river that have public access in order to prevent or endanger kayakers or other types of river regulators? The answer is nobody knows in Colorado right now. This is called the public right to float, and I can give you both sides of the argument, and I don't know how this is going to get resolved in Colorado. Some other states have already resolved this. Montana and Wyoming, for example, have either constitutional provisions or statutory provisions that specifically allow at least certain rivers to be considered navigable. And if it's navigable under the law, then there's clearly public access. Colorado has not gone that far. There was a court case about 40 years ago that didn't answer this question. Everybody hoped that it would, but the Supreme Court kind of dodged this and didn't answer it. There's been a few recent Colorado court cases, but none of them have actually gone to trial, and so we don't have any court action. And there's no statutory help on this. Kathleen Curry presented a statute 2 years ago that would have defined a little bit of the Taylor River as navigable and solved this issue for that particular stretch of the river. It never became law. So we don't know the answer. Here's the two arguments. One argument is that the water belongs to the public. And if it's a public resource, just like the air, then all the members of the public have the right to use it. And so if you're in a kayak or in a rubber raft or whatever, and you're just sitting on the water, you're sitting on something that belongs to the public and does not belong to anybody else. It's not private property. And so you should be able to use it. The countervailing argument is, but that public right is sitting on top of my private property, my land, where the creek crosses. And the only exception to that would be if you have a navigable stream at the time of statehood, then the title to the bed of that stream would have stayed in the public, even though the title to the land might have come out under the Homestead Act or some other act where a patent could be issued. The argument is that I'm a private landowner. One of my property rights is the right to exclude people. And even though there's a public resource, the water running across me, that doesn't mean I don't get the right to exclude people. I don't know how this is going to play out. It has been solved in many places by etiquette, I guess, where people got together and they said, look, we don't know what the answer is, but let's work out a way to solve this problem. On the Arkansas River, for example, it's such a big industry over there, the rafting industry. They went to all the landowners on the stream who were not the Bureau of Reclamation or somebody, and got them to sign easement agreements. And maybe they pay them a little bit of money every year to allow those rafts to go through. So that was a solution that they crafted over there. But there are places where somebody's just not going to want you to float through, and I don't know what the answer to that is. Next question I have is application of water to a seasonal wetland in the fall and spring considered a beneficial use? What type of water right is required? We actually have a fairly new beneficial use that's been recognized by water courts. It's called a wetlands irrigation water right, because some people need to do wetlands mitigation. They're going to fill in a wetlands, or they're going to do a development that's going to impact wetlands. And to get an Army Corps 404 permit, they have to do mitigation and provide some wetlands somewhere else. They then create a wetlands, and they go to water court and get a decree that allows them to irrigate that wetlands. And yes, it is a water right, and that's considered a beneficial use for wetlands irrigation. Question: with less than 35 acres that's been on a well for over 50 years in Douglas County, can you possibly have two wells on your property, one for domestic and one for household? And the answer is no. The rules on an exempt wells, whether they're domestic or household use only, are that you tie them to the property. So if you have less than 35 acres, you can't get a domestic well anyway unless you do an augmentation plan, or that well was there and decreed prior to 1972. So you're only going to I guess I should say, if you have a prior to 1972 domestic well, that's not an exempt well. That would be a fee well, and then you might be able to get another exempt well for household use only, but that would be a long shot, I think. Next question, how was water policed before laws were established? Well, the same way we police them today, I think. If there wasn't a law, then it's whoever has the biggest gun would police the system. And there is a rule that it's better to be at the head of the ditch with a junior priority than at the bottom of the ditch with a senior priority, because it's so easy to go out in the middle of the night and do your own thing and take that water the way you want it. And that happens all the time. I've been involved in many cases where people simply stole the water, and it's very difficult to prove that water is being stolen. Sometimes it takes some sort of physical activity to make that happen. The water commissioners have the ability and the authority to lock people's head gates. And if they lock your head gate and put a warning notice on there, and then you break that lock, you've committed a crime, and the sheriff can arrest you. It's a misdemeanor crime. And usually that only happens once, and then it's pretty well taken care of.
All right, Aaron, that was great. I really want to, first of all, thank you for that presentation. I'm sure everybody has a lot more questions, and they can go ahead and get a hold of me, and we can forward that information on to Aaron if that's something he's interested in working on.
Sure.
We do have another follow-up poll, and we'd like everybody to fill that out if they wouldn't mind here before you exit. And I just want to, again, thank Aaron for presenting today. I thought that was a great talk, and hopefully we answered all your questions you might have had. And then please don't hesitate to get a hold of me again, like I said, and I'll be happy to forward that information on Aaron if it's something that I can help you guys with or a legal issue. And then obviously keep an eye on our website. Excuse me. We're going to have some more of these coming up. Again, we have one next week from the state climatologist, and we also have additional webinars that might be of interest to you, so keep an eye out. And one last time, I want to thank Aaron for joining us today on the presentation. So I hope everybody enjoyed it, and we'll look forward to speaking with you guys next time. Thank you very much.
Bye-bye.